Good evening, everyone. I'm Len Herrick, the publisher of Exceptional Parent Magazine. With me tonight are Richard Miller and Shawna Brown from the law firm Mandelbaum Salzberg, based in Roseland, New Jersey. They're one of New Jersey's oldest and most trusted law firms with 90 attorneys who handle a range of legal issues for business, families, and individuals, including everything related to individuals with special needs. Specifically, they advise families on special needs trusts, estate planning, guardianships, disability benefits, special education, elder law issues, and many other issues relevant to our community. I'd like to mention two things. We want this webinar to be as interactive and helpful as possible. So if you have a question along the way, one that is relevant to everyone, please type it in the Q&A field at the bottom of your screen. We can't promise we'll answer all of your questions, but we will do our best. And regarding questions that are personal to you and your family, Richard has been gracious enough to provide complimentary Zoom consultation for anyone on tonight's webinar. If you're thinking about creating or modifying any planning documents, or if you have questions about a specific situation you're dealing with, please take advantage of this opportunity. All the details and a link to schedule the Zoom will be on our follow-up email. Before I turn this over to Richard and Shawna, I want to extend an invitation to any seminar participants that are not already part of the Exceptional Parent Magazine subscribers. Please go to our site, epmagazine.com, and click on EP for free to receive our publication, our newsletter, and information on events like this, free of charge forever. With that, I'm proud to turn this over to Richard and Shawna.
Thanks, Len. First of all, thanks for setting this up and allowing us to be part of the Exceptional Parent family and participate. It's important, and we're glad to be part of it. And thanks to Jody and Taryn from my office for helping to get this event done tonight. So I also thank everybody participating. I appreciate you spending time on a Tuesday night with us. So we're going to do our best to make this informative, educational. It's not exactly the way that I like doing these things, but we adapt under the circumstances. I like seeing people's faces rather than just my own face staring back at me. I like being interactive, being able to engage with the audience. So we're going to do the best we can under the circumstances. We are going to monitor the questions or the chat to see if we can address as many questions as we can. This is a really important topic, and usually when I'm in groups, I like to see a show of hands about how this impacts certain people. And it's the reason I know this is important. I speak before a lot of groups, and I talk to accounting groups and other professional groups and legal groups, and I often go around the room and say, how many people in the room know somebody that that's in a nursing home? And half the hands go up. And then I would ask, how many people know somebody that's in a second marriage? And it used to be, years and years ago, there were a few hands, and now there are a lot of hands that go up that they know folks that are now in second marriages. And then I would ask, ordinarily, I like to see a show of hands. How many people know a family that has a special needs child or somebody in their family with special needs? And the hands all around the room would go up. So this is a topic that touches many, many people. And one of the things is that everybody likes to help. And there's a lot of information that's out there, but there's also a lot of misinformation. And people try to offer their opinions, and they tell folks what they've encountered through their own personal circumstances, but it's important to know every circumstance is different. And it's not one size fits all. So what our goal is tonight is to just share some information, some things to be aware of, think about. You can, kind of do your own personal inventory, whether or not you have some of these plans and documents in place, and some things just to think about where we see some of the more common mistakes and places where plans tend to not really work. So with that being said, I am going to turn it over to my partner, Shawna, and she is going to start with a discussion about some estate planning essential, basic documents that everybody should have, regardless of age, regardless of circumstance. So with that, let me introduce Shawna.
Thanks, Richard. Good evening, everyone. It's a pleasure to be here with you tonight and to talk about this topic. So I'm just going to dive right in. So when a client comes to our firm and says, I need estate planning, the typical suite of documents that we'll talk to them about preparing are a will, a power of attorney, and a living will. About each of those documents in turn. And many of you are probably familiar. Again, this is when I raise my hands and I tell people to raise their hands and say, does anyone have these? But I'll just have to trust that you're raising your hands. So I'll start with a will. So the primary purpose of having a will is to lay out your wishes for how your assets are distributed upon your death. So, you know, some of us think of, you know, movies where someone passes away and they say, oh, you know, we're all going to the reading of the will. And then they say, you know, this person is getting this object or this person is getting the whole estate. And in real life, I've never done a will reading.
Which, by the way, I have to just interrupt you because this is a movie recommendation. Anybody that wants to see a great movie about a reading of the will and challenging a will, which I talk about in another seminar, you have to see the movie Knives Out. Came out about a year or two ago. Great reading of the will scene. Highly recommended. Sorry.
That's okay. I haven't seen it. I'll have to watch it now. So, but a will does lay out someone's wishes, and it can be as specific as you want it to be. It can, you know, give away every single item you own, or it can be very general. You know, I give everything to my spouse. I give everything to my child. So it's really tailored to how you want it to be. And because a will lays out what will happen to your assets upon your death, it's something that doesn't take effect until a person passes away. So it can be changed and modified over the years. Some people think that you do a will and that's it, and it's not it. You can continue to change it as your life circumstances change. For instance, the death of a family member or other issues in your life. So a will also allows you to choose an executor, who is a person who will essentially be in charge of your estate and carry out the wishes you lay out in your will. So that includes, you know, submitting your will to the court so that it's validated by the court. And they call that admitting it to probate, gathering your assets, paying any debts that you might have, and making distributions. So you may be hearing this thinking, you know, perhaps you have modest assets or you don't think you need a will, but a will is really important for everyone to have. And it's particularly important if you have children, because in a will, you can lay out, especially with minor children, you can lay out in there who you want their guardian to be upon your passing. So let's say you're married and something were to happen to you and your spouse, you can appoint a family member or a friend, someone you trust, who would essentially become your kid's legal guardian if he were to pass away. So another thing that you can do with a will, which is great, is that if you have a family member with a disability, you don't want assets to come into their name necessarily, because that may disqualify them from certain government benefits, such as Medicaid or SSI. And you can create a trust within your will so that those assets go into a trust, which is a vehicle that shields it from being looked upon as an asset when government benefits are being considered. So a will can be very simple or it can be extremely complex. It really is tailored to your particular situation in your life, but it's a really important document to have. And if you don't have one, what happens is your assets, they could pass a couple of different ways. One way is through what's called intestacy. New Jersey has laws that actually say how your assets pass upon your death if you don't have a will. And for many people, it would probably pass the way you'd want it to, you know, to your spouse or to your children if you have them. But it also might not. If you're a person who is not married and, you know, would rather leave your estate to a close friend, then that wish may not be effectuated. It's also possible that you may have assets that are in a vehicle such as life insurance or a bank account that has a named beneficiary. Richard will talk more about that later. And in that case, that would pass to that named beneficiary, not according.
It was a question that popped up. Can you have more than one executor?
Yes, you can. You can have co-executors, and a lot of people do that. The only caution that I place on that is, you know, sometimes too many people create problems because they might not agree, you know, as to how your wishes should be carried out. Even though it's in your will, there are still going to be decisions to be made, such as, you know, if you own a house, you know, what realtor are you going to hire to sell the house? If there's tax returns to be done, what accountant are you going to hire? When are you going to make distributions? So those things could potentially lead to conflict. So if you want one person, that's fine. If you want two people, great. 3 or 4 might be a little bit too much, unless they're really, really in sync.
One thing I just wanted to add to something Shawna said is she mentioned that in a will, it's the vehicle that you can name a guardian for minor children. But I think it's important to distinguish, and this came up this week, actually, a question I had, is that if there is and we're going to talk more about guardians for children or young adults that turn age 18, what Sean is talking about are for naming guardians for children under the age of 18 that are still not legal adults. But for guardians of individuals over the age of 18, a will does not allow you to automatically name a replacement guardian. What it is you can nominate a person to become the guardian, but it does not automatically appoint a replacement guardian. Somebody that has a guardian appointed over the age of 18 by the court, a replacement must be appointed also by the court. The will not control that outcome.
Right. That's a good point. I get asked that a lot. Another thing that I've been asked is if I'm preparing a will for a client who's divorced and has minor children, if they do not like their ex-spouse, sometimes they will say, well, can I nominate a different person other than them as guardian of my children? And the answer is, you could put it in your will, but that's something that would have to be adjusted through the family court. That's not something you can do directly in a will.
The other thing I want to add, I know it's off topic, but I want to place, just kind of put this in the back of your heads. A will has a tax clause as to who pays taxes. Now, most of the time there's no taxes because estates have to be extremely large, over $11.4 million to worry about federal taxes. New Jersey no longer has an estate tax. It may or may not come back. New Jersey still has an inheritance tax, and that creeps up on people. Most people don't care about it or don't know about it because there's no tax on assets passing to parents, children, spouses, stepchildren. So anybody in that immediate bloodline is generally not paying an inheritance tax. But if you're leaving it to brothers, sisters, nieces, nephews, friends, or anybody other than charity or companions, people that are together, significant others that are not married, there could be an inheritance tax. And the will controls who pays the tax. So this is a mistake that creeps up on a lot of people. They don't realize that there's an important clause in there, whether it's paid as an administrative expense or is it paid by the beneficiary who receives the assets. So when you're doing this, it's important to know that there is still some tax out there that you need to be aware of, even if you don't have large estates. And B, who do you want to pay that tax so there's no fights later on?
Right. And that's another good reason. Another question I get asked a lot, mostly in my personal life, is, can I do a will from something I print off the internet? And can you? Sure. But it's really best to go to a professional who can address these issues and make sure that your plan reflects exactly what you want, rather than something you print offline, which may be very general and not address for all these contingencies and options. So another document that we frequently prepare and recommend to clients is a power of attorney. And that's a document that controls during your lifetime. And what it controls is financial and personal decision-making. So the classic example is somebody is, for some reason cannot make their own decision. Maybe they're undergoing a surgery or they develop a cognitive issue where they can no longer make decisions. And the power of attorney can allow an agent that they appoint in the document to access their bank accounts, to have them admitted to a facility if that's necessary. Sometimes people are in a hospital and they need to be admitted to a nursing home or an assisted living and they can't make that decision for themselves. So a trusted agent can do that for them. It also can be used in terms of planning, where if someone needs to be put onto a government benefit such as Medicaid, the necessary gifting and asset transfers can be made to render them eligible for that program. So the power of attorney is a really important document. So in it, like I said, you name an agent. You can also name co-agents, so more than one person if you wish to make decisions for you. And it can begin to take effect immediately upon you signing it, or it can be a springing power of attorney. And in that document, there's a provision that states, if something is to happen to me and doctors certify that I cannot make my own decisions, then my agent can act. So I can't tell you how many times we get calls from people who say, I have a parent or a loved one who's in the hospital, I need to now transfer them to a nursing home or an assisted living, and I can't do it because they don't have a power of attorney. And then they have to do a guardianship, which we'll talk more about later. But having the power of attorney document can be such a cost-effective means of having authority to do something in an emergency, rather than going into court and having to get a guardianship and get legal authority over somebody. So it's a really important document to have. And even if, someone is just undergoing surgery, and there's some decision that has to be made when they're in surgery about something financial, or a bank account has to be accessed, then that can be done. So a power of attorney is really important for anyone who's over age 18. So even if you have a teen who's going to college and is going to be going away, when they turn 18, you as a parent don't have authority over them anymore. They're adults. So it's important for everyone to execute a power of attorney to designate someone in the event something happens, or they're not present and want to designate you to do something for them.
One thing that's important to know about a power of attorney is that it is revocable. It can be changed at any point. One question we get a lot is that people are fearful that if they give a power of attorney or a designation of an agent to someone else, they lose their rights. They're giving their rights away to somebody else. That's not the case with a power of attorney. You are extending your rights. That does not mean that you do not have the ability to make your own decisions. You're just allowing somebody else to make decisions for you. Sometimes that's a scary idea for seniors that, feel like they're losing some autonomy and independence. And the same thing, you may have a college age student that says, I don't want mom and dad making decisions for me, but it's a good idea to have in the event, you want to make sure that you have access to their grades, or you can speak to somebody in case they get in trouble. But it is a revocable document. It can be ripped up. It can be revised at any point. And if the person disagrees with the agent's decision, the person controls. They can override a decision by an agent under a power of attorney.
Right. And with all of these documents I'm discussing, it's really important when you name an agent to also name a successor agent or a successor executor in a will, because if something happens to the person that you appoint, or they're unable to serve or even unwilling to serve, it's important to have someone else that you designate that you also trust that can step into that role. So the next document is a living will. And that document controls medical decision-making. So the way we do the document is that you lay out your end-of-life decision-making. So if a person is in a situation where they are ill, unfortunately, terminally, and there's no chance of recovery, sometimes people call this a pull the plug document, that they can say, I don't want to be kept alive artificially, because many people feel strongly about that. They don't want to be kept alive on a machine. We've all seen stories on the news about that. Or you can make a decision that, yes, I do want to be kept alive, artificially, because that's just my value system or what I want. And that's a really important document to have so that, your family and your agent aren't questioning what to do if you end up in that situation. Then they know what your wish is. You can also lay out in that document your wishes for organ donation, and that can be as specific as you want. I've seen people be really, really specific about that. And also, other things like anatomical gifts. Some people, want to donate their body to science. So some people are totally uncomfortable with those ideas, and that's okay too. But at least you're giving some certainty to it for your loved ones so that they know how to handle that.
Let me just go through some of these questions real quick so we can do them as we go. Some of them we're going to talk about a little bit more in guardianships. So if a person has a guardian and passes away, does a power of attorney kick in? No. Like I said earlier, if there is a guardian and that guardian passes away, someone needs to go to court to get appointed as a successor or substitute guardian. I'm going to mention that a little bit later. Is a guardian separate from a power of attorney? Yes. You have to make a decision whether or not a power of attorney is appropriate, or sometimes a guardianship is appropriate. Sometimes it's a borderline call. Sometimes it's a gray area. A person is capable of signing a power of attorney, which is a standard that's fairly low. You need to know do you trust the person you're giving authority to? Do you understand that you're giving them the permission to act for you? And if you can understand that, then you can do a power of attorney. But there are weaknesses. Like I said a moment ago, just because you give somebody power of attorney doesn't mean you relinquish your rights. So you still have the ability to do things on your own, which may be a good thing, or it may be a bad thing, depending on what the person elects to do. And that's when you have to weigh whether a guardian is more appropriate than a power of attorney. But it's a decision that needs to be made on a case-by-case basis, particularly when you have a high-functioning individual that can theoretically sign a power of attorney and healthcare proxy, but it may not be as comprehensive or appropriate in all circumstances. And same thing, there's no right or wrong what's best for a child. It's a case-by-case basis depending on their abilities or their limitations and things that you really need to, that you're looking to address. Are you looking to make sure they're not financially exploited? Do you want to make sure that an individual doesn't go sign a contract for a lease on a car? Now is creating a financial responsibility. The real issues, sometimes the challenging ones, are especially when you're dealing with mental health in the mental health community, then it's really difficult, where you really, whether a guardian is appropriate or a power of attorney. So there's no one size fits all. It is a case-by-case basis depending on the circumstances in that family and in particular of the child.
The thing that I should point out is if someone does have a legal guardian appointed for them and they're an adult, and they have a power of attorney and a living will, the guardianship supersedes those documents. So the guardian now has authority to make those decisions as opposed to the agent under a power of attorney who could be a different person.
Here's another question that I see in the chat. Is a living will similar to a healthcare directive? So there's a lot of different names for the same thing.
I mean, the names, I think the names that I hear changed around are living will, advanced directive, healthcare power of attorney. The document that I refer to as living will that we prepare usually includes both an end of life decision making and what I think of as my head as a healthcare power of attorney. And that's designating an agent to make healthcare decisions for you in the event that you can't do so. So that would come into play either at end of life, or if someone is having a surgery and that decision has to be made and that person can't make that decision. If there's some kind of a temporary, loss of consciousness, then somebody can make medical decisions for you, and they can also get your medical information. So if they need to speak to your doctors or get copies of your medical records so they can sit down and evaluate what's going on, they can do that as well. And that's also a document where you should have a successor agent designated in the event that your agent, can't or is unwilling to serve. And one consideration is, it's fine to appoint anyone that you trust as your healthcare agent, but you may want to consider where the person lives. If they live far away, they might be a great agent, but if you're in the hospital, you might prefer to have someone who can get there right away and actually see you, talk to the doctors, get a feel for the situation. You also might want to be cautious, like with other documents, appointing co-agents, because medical decision-making is a highly sensitive issue. So you may prefer to designate one person to do it and make those decisions. But again, if you know two people who are very much in sync, you can have co-agents for that as well.
All right, so I am going to just switch gears here for a minute. And this is all going to come together at the end, and it's all going to make sense. We're kind of doing it in piecemeal, but this all really relates to one another. So the next topic we want to touch on is how do assets pass when someone passes away? And there's two types of assets, and Shawna touched on this a few minutes ago. There are probate assets and there are non-probate assets. Probate assets are assets that pass through one's will. So the will control where those assets will go or they will not go. Non-probate assets pass outside of the will. They are not controlled by the terms of the will. Now, this would be the time where I would look you in the eye and I would ask the question to come up with examples of probate or non-probate assets. I would like to know examples. What are some examples of assets that pass outside of the will and go directly to the individual regardless of what the will says? So we'll see if this works since we have a lot of people out there. Throw it in the chat. Give me some examples of things that do not pass through the will. Let's make believe this is like the speed round on some game show that I want to see who can type these answers.
Right. Oh, good. Okay.
Life insurance.
Good answer.
from, I can't see the name and I'm not putting on my red glasses because my other one's broke.
Advisor, retirement accounts.
Okay. So good. We should have prizes for the first 5 people. And we'll have to do that the next way. No. Social Security benefits, no. Life insurance, yes. Retirement accounts, yes. What? What, Renee, really? Yes.
Oh, good. Okay.
Adele is right. Bank accounts with POD, good. Anything else? All right, we got about half of them, or almost all of them. Trust, yes, okay, so trusts. In trust for accounts, so someone said payable on death. So a payable on death account is similar to an in trust for account. Both of those things pass directly to a beneficiary. Safe deposit box, well, maybe safe deposit box, but I'm looking for something. How do most people own their homes? Anyone? How does a husband and wife or deed? No. How is the deed titled?
For the form of ownership.
There you go. Catherine got it. Joint tenancy, correct, jointly. So these are all examples of how are non-probate assets that pass out of the will. So property owned jointly with right of survivorship or joint with right of survivorship. So a house is an example if 2 people are on and it's a designation of joint with right of survivorship. Bank accounts could be jointly owned and assets will pass automatically upon the death of the first one to the other person named, whether it's a spouse, child, or anybody. There's a joint owner. The default rule is it will automatically go to the other joint named individual. IRAs, 401ks, anything that has a beneficiary designation will go to the beneficiary regardless of what the will says. Payable on death accounts, same thing. It will go to the payable on death beneficiary. Life insurance has a beneficiary, so the asset will go directly to that. In trust for accounts or other assets in trust. So those are all examples of things that pass outside of the will. So if you take a step back, this covers practically 90% of what most people's assets are. So the will is important and it shouldn't lose its relevance, but people have to understand that the majority of their assets will pass outside of their will. So it is critical to know who your beneficiaries are, and you have to determine whether or not your beneficiary designations are consistent with what your wishes are. Do you want the beneficiaries to get the assets who you name, as opposed to what your will says? So it's really important when you do your estate planning and you do your planning in these situations to know exactly how your assets are titled. Does it have a beneficiary? And then decide whether or not the beneficiary designation is correct.
So Richard, there's a question here. Does it matter if the beneficiary is a minor? And what are the tax consequences of that? And who would be responsible?
Excellent. You just was a great segue. So thank you.
Thank you, Eileen.
Yes, that's exactly what I was about to say. So a good example is if you have a trust for a minor. So a will, as Shawna pointed out earlier, often has a trust for someone under the age of 21, or some people leave it in trust until 30, 35, or some people leave it in trust for the lifetime of a child. But particularly with minors, if an account, whether it's life insurance or retirement account or any payable on death account, is left to a minor, it's going to get stuck in the account because a minor cannot inherit assets directly. So it's going to be stuck with the life insurance company, or a parent is going to have to apply to be the guardian of their child. It's a different type of guardianship, but you basically have to register with the surrogate's court, become the guardian of the child, post a bond to get control of the assets until they turn age 18 or 21. So it's a mess. So if a child receives money as a beneficiary, it's a mess. So in order to tie this together, you want to name the trust for the minor that's established under the will. So the trust for the minor will be the beneficiary, not the child. And it's equally important, which we're going to talk about in a few minutes, particularly if the child is receiving government benefits. You do not want the child on government benefits to accidentally be the recipient of an inheritance, because it will disqualify them from the government benefits. There are ways to fix it. We'll talk about those, but it is crucial, and I cannot underline it enough, to know what the beneficiary designations are and determine whether or not they accurately represent your wishes. And we're focusing on special needs today, but this has all sorts of applications. And we see will contests all over the place because, a call just came in today. All the assets passed outside of the will to one daughter. The will left it equally 50-50. So the one daughter got everything because she was beneficiary of the account. The other daughter got the honor of being named 50% beneficiary of the will, but then was met with the reality that she gets 50% of nothing. So she's not happy. And we see this all the time. So that has a global implication. But with respect to special needs planning, it is really critical to know beneficiaries so assets do not accidentally pass to individuals who are on government benefits.
All right, another question here. If an adult child is affected by an intellectual and developmental disability and they pass away, do they need to have a will?
It depends. If the person has a guardian, that means they have been adjudicated as incapacitated, and they are not permitted to have a will without a court authorizing the execution of a will. They have to have the requisite capacity to sign a will. If an individual has not been adjudicated incapacitated, then they will have the ability to do a will, provided they meet a minimum standard. And they basically need to know who they are, who the natural objects of their bounty are, who are their relatives, their immediate family, and they have to have a basic understanding of the assets that they choose to leave. It's a very, very low threshold, but it's a case-by-case basis. So you can presume that if a guardian has been appointed by the court, an individual probably cannot do the will. It's possible, it's not likely. If a guardian has not been appointed by the court, then it's a case-by-case basis, and the attorney or the person witnessing and notarizing the will has to feel comfortable that the individual has the capacity to understand what they're doing. All right, so I think that is it on probate and non-probate assets. So let's talk a little bit about guardianships. So guardianship is different than a power of attorney. So a power of attorney is not a court supervised process. As I said, it is revocable. A guardianship requires a court procedure in order to adjudicate somebody as incapacitated. And the definition of incapacity is an individual that is not capable of handling their personal, financial, legal, or medical affairs. It's a very broad definition, and a lot of people can fall in it, and it's not black and white. It used to be. Years ago, it was either you're competent or you're not competent. Now, there are shades of gray as capacity is concerned, and it really depends on carving out what aspects of life can people make reasonable decisions about. Someone may be able to decide what they like to eat, what entertainment they want, what clothing they wear, who they wish to vote for, whether they can get married, but they may not be able to make reasonable or appropriate medical decisions for themselves, or they may not be able to handle money properly, and they may need a guardian, and a power of attorney may not be satisfactory for a situation like that. There are two types of guardians. There's guardian of the person, meaning the person making decisions for that person's where they live, educational decisions, things of that sort, and guardian of the property. If there's any money, the guardian of the property is in charge of the money. So guardianships are very common, and it needs to be considered when any person with a developmental disability or intellectual disability is approaching the age of 18. Because as Shawna pointed out earlier, when a child reaches the age of 18, they are emancipated, and you no longer have the right to make decisions for them as a parent. You don't have the right to technically talk to the school. You don't have a right to see their grades. You don't have a right to make other decisions for them. Even doctors are technically not supposed to speak with you because of HIPAA restrictions. So it may be that the child says to the doctor, gives permission to the school to speak with you, but that could stop at any point, particularly if the child is a little bit more profoundly disabled and they don't have the ability to authorize sharing information. So these things should be considered as a child turns age 18, because you do not want there to be a gap of time where a parent now does not have the authority or ability to participate in the child's needs if necessary. Now, we'll talk about in a second that there's some challenges with doing guardianships, but there are also other types of protective arrangements besides a guardianship. So I'll have, Shawna is going to talk about some of the other protective arrangements that exist in New Jersey other than a guardian.
Right, so New Jersey has a protective arrangement law, and a protective arrangement can be appropriate when you want to help someone with something, but you don't necessarily want to take the step of going full throttle with a guardianship. So some instances where this could be used are, let's say, someone you're concerned about their cognitive issues or capacity. You're not quite sure if they need a guardian or not, but maybe they're being financially exploited by somebody, or they're not caring for themselves properly. And you want to have some authority to help guide them through going to doctors or getting the right care. You might seek a protective arrangement and tell the court, I'm worried about this person. They're being exploited, or they have this problem. They're vulnerable. Here's a description of what their condition is like. Here's what I've done to try and help. It hasn't been successful. And ask the court to basically set into place an order where they allow you to do certain things for that person, but that person still is not the subject of a guardianship. Now, it's always possible a protective arrangement could turn into a guardianship as things progress, but it's sort of a less restrictive means. Another example would be, let's say, there's someone who is resistant to talking to you. To do a guardianship, you need to actually have doctors examine a person. So maybe it's something where it's a challenge to get a doctor to examine them, so you aren't really sure what their situation is, but you still have that concern. And what the court does is they appoint an attorney called a guardian ad litem, who examines the situation and makes an evaluation to the court in that person's best interests as to what should be done. So it can be really useful in cases where you don't want to do a guardianship for some reason. Perhaps, you just don't feel comfortable with that, but you feel like it's really important that something be done. Perhaps a senior citizen in your life is being financially exploited. A disabled relative maybe isn't getting the care they need. Maybe they're living with another relative and you're concerned about how that person is treating them. You want more access to them. These are all things where you could seek a protective arrangement.
Okay, so Shawna hit on a couple of the issues with the guardianship process itself. So you don't want to undertake this lightly. Because it is a process. It's costly sometimes, it's involved, you have ongoing court supervision. So with a guardianship, as Shawna pointed out, it starts with doctor's examinations. And generally with a non-DDD guardianship, because there's two types of guardianships, a DDD guardianship and a traditional guardianship. With a traditional guardianship, you need two doctor's reports. And those two doctor's reports have to have an examination within 30 days of filing the papers with the court. And the doctors need to do an assessment. And by the way, everything now is done by Zoom. The courts have relaxed all of the rules. So examinations can be done by FaceTime, by Zoom, by telephone. So all of the things that used to be done in person can now basically be done remotely. But it still requires two doctor reports to start a guardianship complaint. A complaint is like any other lawsuit. It is a lawsuit filed in the Superior Court, but it actually gets submitted to the Surrogates Court as the clerk for the Superior Court. As Shawna pointed out, there's a court-appointed attorney assigned in every case. It doesn't matter whether or not you're dealing with a grandma in her 90s that doesn't know where she is on any given day, or you're dealing with a very high-functioning 18-year-old that is needs a guardian, but is also very capable of expressing his or her opinions. A court-appointed attorney is assigned all the time. It's required under the law. And that brings its own challenges because sometimes it's a very smooth, uneventful process where it's a black and white guardianship. But sometimes if a person disagrees that they need a guardian, it can be pretty contentious. And the court-appointed attorney's job is to advocate for the person if he or she objects to the guardianship. So sometimes it gets a little bit difficult, and then, of course, the more difficult it gets, the more expensive it gets. But it is important to evaluate whether this is appropriate, again, when children turn age 18. Now, with a DDD guardianship, thankfully, the rules changed a few years ago, and they've streamlined the process and made it less involved and less expensive. So with a DDD guardianship, which is one where a child is affiliated or eligible to receive DDD services, then you do not need two doctors. You only need one doctor, and that doctor report can be done, or the examination can be done within 6 months of filing the complaint for guardianship. And instead of a second doctor, you can use an IEP as long as the IEP is within the last 2 years. The other benefit of a DDD guardianship is generally the court-appointed attorney will be assigned on a pro bono basis. So it's supposed to be the public defender's office that is assigned to these cases, but the public defender's office is generally overbooked, overwhelmed. So the courts will traditionally name a private attorney, but ask that attorney to serve on a pro bono basis. But it is a process, and it is still, by the way, people can do this on their own. The courts have been very user-friendly, where you can go online at the office of the courts, and there are forms to fill out, and people do this on their own. Some people prefer not to, just like some people like to change the royal, which I've never done in my life. So everybody, can do things on his or her own, but this is something that you can do by yourself. You do not need an attorney, although most people, I would say, probably choose to use one.
We have a couple questions. So Lisa says that because of COVID, she couldn't get into the courts before someone turned 18 for a guardianship. And she says this is actually out of state in Nevada. So yes, I mean, if you don't get guardianship before someone turns 18, you can certainly seek it after they turn 18. That's fine. If you have a child who's approaching age 18, it's a good idea, I think, in the months before, as they're approaching 18, to start thinking about a guardianship and getting together the information you need. Someone else, Jeannie, asks, what does DDD stand for? That's the Department of Developmental Disabilities. Is that the right? Division
of Developmental Disabilities, yeah. There was another one I saw. Can someone vote or get married? Yes, if someone is adjudicated, well, it depends. If someone is adjudicated as an incapacitated person, the court-appointed attorney in the report to the court is supposed to identify rights that can be carved out and retained. So you could be as creative as you want. Maybe it's appropriate for the individual to retain the right to have a certain bank account that they do not have to account for. So they can have $100 a month, and even though they may be incapacitated, they can still have a limited amount of money. The judgment of incapacity could retain the right to vote. You can retain the right to marry. That would be something a judge would need to consider a little bit more carefully. You even have the right to do a will. You can retain the right to drive. All of these things can be considered as part of a guardianship proceeding. That's why these things are not, pro forma documents. It should be tailored to everybody's situation. I think some care should be put into the judgments so that it does allow people to have the maximum independence and autonomy and have their wishes considered, even if somebody else is making the ultimate decision for them.
Right. I had a client who wanted to retain the right to get tattoos and choose tattoos. So, I mean, it can be really, really specific because certain things are really important to people and, they want to retain that right. So
the other thing is to be proactive, and this question came up as well earlier this week, is that, be proactive with successor guardianships. We've already mentioned that you cannot name a successor guardian in a will. You can do it for a minor who's under age 18. You can't do it for somebody over the age of 18. So if someone gets a little bit older and maybe they realize they're not going to be around forever and you're going to need a backup guardian, it may be a good idea to name a co-guardian immediately. Go to court now, have the co-guardian appointed currently so that there's a nice, seamless, smooth transition. So if one person is really not able to act any longer or is going to take the back seat, you have somebody in place that's able to take over should the situation require it. So be proactive, don't react. You should take the steps ahead of time instead of having to deal with emergencies.
Right, and commonly that'll be someone's parents would be appointed as their guardian, but also with one of their siblings who's younger. So if the parents, as they age, decide they don't want the responsibility or can't fulfill it any longer, then their sibling seamlessly steps into it.
Okay, so that's guardianship. So next topic that we want to cover is Social Security disability versus SSI, social supplemental security insurance. This is something that people get confused about. The names are used interchangeably, but they're very different programs. So when we ask somebody, you know, does the beneficiary get Social Security, or if we say, do they get SSI or SSD, you know, the answer is, well, they get Social Security. Well, that doesn't tell us whether it's Social Security disability or supplemental security insurance, SSI. The reason it's important to know the distinction is because if someone is on SSI, that automatically comes with Medicaid benefits. So if someone's on SSI, they cannot have more than $2,000 of assets. And if they receive $2,000 of assets, then they're going to get disqualified from not only this SSI program, but they're also going to get disqualified from their Medicaid benefits. Now, SSI is for somebody that does not have any work credits, generally has not been employed for any extended period of time, and has no money. Social Security disability, on the other hand, is for someone that's been in the workforce, they've received paychecks, and they've had their Social Security withheld from those checks over a period of time. And they are then entitled to Social Security disability, irrespective of how much money they have. So, you know, you could be a millionaire, a billionaire, you've paid into the Social Security system. If you get hurt, if you get disabled, you are entitled to your Social Security disability payment. And after 2 years on disability, you are then entitled to Medicare, even though you may be under the age of 65. So it is critical to know which benefit program a beneficiary is on. If a person is on SSD with Medicare, then they can inherit assets and it's not going to disqualify them from their government assistance program. If an individual, on the other hand, is on SSI, any money they receive as an inheritance could automatically disqualify them from not only the income they receive, but the Medicaid benefits they get along with that program. So real important to know, Social Security benefits are not just Social Security benefits. Know if they're SSD, know if they're SSI.
There's some questions, Richard. So Eileen asks about the resource limit. Is that in New Jersey or the whole US?
SSI is a federal program. Well, both of these are federal programs. So these are federal rules. So this would apply throughout the US.
Then Ed asks, what about a child of parents who are receiving Social Security retirement income?
That's a whole nother seminar. And I would recommend going on to the Social Security website because there are a lot of sub-programs for children of people receiving, children of parents receiving retirement benefits get a whole nother set of benefits. So that one is a whole nother can of worms. Go to Social Security website. They have all the answers, but that one we don't have time for because there are a ton of benefits for children that have parents that have passed away and so on and so forth. So, because I want to move on, we only have about 10 more minutes, and I want to touch on another couple of topics that are real important. So the next topic is special needs trust. So this is kind of similar to what I just said about Social Security. People reference special needs trust generically, but it is important to know that there are two types of special needs trusts. And the way I distinguish them is I call them different names. So we have the umbrella of special needs trusts, and then one branch of that is what I call a self-settled trust. Sometimes we call it a first-party trust. So what does that mean? So a self-settled trust is funded with the assets of the individual, him or herself. So if somebody has assets and they are under the age of 65 and they are disabled and they come into money and they're receiving SSI, they're on Medicaid, they receive money unexpectedly, and they're under 65, they can have a self-settled trust created with their own money, and that money will not be considered a resource for government benefit purposes. Now, that's the good news. The good news is that you are able to maintain your benefits, you're able to create a trust for yourself or someone can create it for you. It could be a parent, a grandparent, a court, a guardian. And that will allow you to have money available for the rest of your life and still not disqualify you from government benefits. Folks over 65, this does not apply for. But here are the two biggest downsides to a self-settled special needs trust. One is that there is a payback provision to the state. So Medicaid keeps score. They know exactly how much money they pay out for every person, and they keep it in their computer system. And a special needs, well, a self-settled special needs trust, a first-party trust, must, under law, contain a provision that says that any money left over in the trust upon the beneficiary's death will be paid back to the state to compensate them for all the money they've expended during that person's life. So that's a big strike. The second big strike is because Medicaid is keeping score and they expect money to be paid back to them later, they want to know exactly how the money is being spent during the lifetime of the beneficiary. So they want to make sure that there's no extreme distributions made. So anything over $5,000, state permission is required. They want to make sure no one else but the disabled individual is benefiting from this trust because it must be for the exclusive benefit of that individual. So special needs trust in a self-settled special needs trust, extremely valuable in order to keep somebody on benefits, but there are drawbacks to it. So there's several ways a self-settled trust should probably be created. One of the biggest ones is that I see uniform transfer to minor accounts, uniform gift to minor accounts. So accounts are set up for children before they turn age 18. And it's an account, UTMA or UGMA account. When that child turns age 18 or 21, it will then vest and become their asset, and it could disqualify them from government benefits. So you want to make sure that if they are going to be eligible for SSI or Medicaid, you want to make sure that UGMA or UTMA account is transferred into a special needs trust so it does not disqualify them. Shawna and I deal with this problem every day where parents unexpectedly are faced with the proposition that, oh, we thought we did a good thing by creating this account, or grandma or grandpa created this account, and now all of a sudden it's the very account that's knocking the child off of benefits. So that's an example. If an individual inherits something accidentally, that would be an example where now it becomes their asset, and now you have to put it into a self-settled trust with a payback provision. Someone may get into an accident and unexpectedly now become disabled, and they need to take their assets and put them in a trust to pay for nursing home care. Otherwise, the assets are going to be depleted. And then the big one where this all ties together is you accidentally name somebody as a beneficiary on an account who's receiving government benefits. They now receive the money as beneficiary. In order to salvage the situation so they're not disqualified from government benefits, you may need to put it in a self-settled trust, provided they're under age 65. But the downside is that payback provision and the annual reporting to the state of New Jersey. So let me compare that to the third-party trust. That's the other type of special needs trust. So I call this a third-party supplemental benefit trust. What's the difference? The major difference is the money is being funded by a source other than the disabled individual who's on government benefits. A parent, a grandparent, or any other source. So this is where you need to tie your estate planning together. So instead of leaving money directly to an individual who may be on government benefits, the idea would be to leave the money directly to a third-party supplemental benefits trust for the benefit of the individual who's on government benefits. So the money does not pass through the hands of the individual, and since it goes into a third-party trust funded with a third party's assets, the trust does not require the same restrictions. So there is no payback provision, which is fantastic because then the person who creates the trust can then leave the assets to whomever they want after the death of the beneficiary. And there's no annual accounting to the state of New Jersey. So there's a lot more flexibility of how the money can be used and no oversight from the state. So there's a lot more opportunity to save the money and a lot more flexibility in how the money can be used. So it is critical that when you go through your beneficiary designations, that you do not name children, you do not name the estate, but you name the third party benefit trust to be the recipient of certain accounts and certain assets, though it never passes directly into the hands of the disabled individual, thereby allowing you to create the trust that does not have the payback provision, as opposed to the trust that requires a payback provision. One of the things that we're going to send out to everybody, Jody's going to take care of this, is in one of the more recent editions of the magazine, we wrote an article on the difference between first-party trusts and third-party trusts. So we will send that article out to everybody. So this will be explained in a little bit more detail. But it really is important to know the distinction and tie this together with your estate planning so that your assets are left to the correct trust. So you're not winding up fixing the problem by it accidentally going to somebody on benefits and then having to pour it into a first-party trust. You want to nip that in the bud and have everything go directly to a third-party trust. So that's the distinction between the two. And now Sean is going to talk about the ABLE account, which is kind of a offshoot of the first-party self-settled trust.
Yeah, I'm going to touch on that, and then I see we have some questions, and we'll address those at the end. I just want to make sure I get this in. So an ABLE account is a tax advantage savings account, and it's kind of similar to a 529, and I'll address a question that was emailed earlier about 529s and ABLEs when I get to the end. I won't forget about that. So an ABLE account, I really like this kind of account because I think it really benefits a person who has a disability but is working and is earning money and wants to be able to save that money in a vehicle and not worry about getting disqualified for government benefits. So with an ABLE account, it's a bank account, and the assets in that account are not treated as an available resource when government benefit programs are considered. So you're eligible to have an ABLE account if you have a disability and the onset of your disability was prior to turning 26 years of age. So if it happened when you were over 26, you cannot take advantage of an ABLE account. However, you can open the account at any age. You could do that in your 30s or 40s if that's when you chose to do it. The total annual contribution to an ABLE account is $15,000, and those contributions can be made by the disabled individual or others. In addition to that, a person who is employed and has an ABLE account can contribute compensation up to the federal poverty level. In 2021, I think that's just under $13,000 a year. And that can be done unless that person's employer has made a contribution to a retirement plan for them. The first $100,000 in an ABLE account is exempt from the SSI resource limit of $2,000. So if you have an ABLE account and it exceeds 100,000, you will have your SSI suspended, but you can still get Medicaid. In the state of New Jersey, the upper limit balance for an ABLE account is $305,000, and any income earned by the account is not taxed. And you can invest the account if you want to in securities if you'd like. Unfortunately, in New Jersey, the contributions are not tax deductible, so you can't take advantage of that tax deduction. But it can be used for qualified disability expenses such as education, housing, transportation. So a great use of it could be, if someone is employed and they need money for a car, they can save money and pay for that car that way. If ABLE funds are applied towards an expense that is not a qualified disability expense, there is a 10% tax penalty applied towards those withdrawals. You need to establish the account in the state where you live. So if you're a New Jersey resident, you have to establish your account in New Jersey. And there is a payback provision that Richard had touched upon before, talking about the trusts. So if there's money remaining in that account and government benefits were expended for that person, there is a payback provision. Now, someone had asked a question before this about having a 529 plan for a child who, because of disability, may not be able to attend college. And yes, you can roll over funds from a 529 into an ABLE account. The contribution limits are still in place though, so you need to be careful about that. And another thing is with a 529, even if you hold on to that and the beneficiary of it is a disabled child, if you make a withdrawal from it, it might not result in the same tax penalty that would result if you withdrew for a non-disabled child. So if you're working with a financial advisor on your 529, it's probably a good idea to discuss that with them and see what the tax implications would be. And typically, a 529 account is owned by the parent and not the child. So it also, if it's held on to, it may not create a government benefit problem because it's actually in the parent's name and not the child's. So don't rush to move the 529. It might be a good idea to talk to an advisor about that and see what the options are.
Okay, a couple of points. I believe that's right. I think you can do able accounts in different estates. That was a comment that I believe that's correct. The main value of an able account is that it really allows the person to have self-determination over their own assets. A special needs trust, a self-settled special needs trust, I'm violating my own rule. Self-settled special needs trust, the beneficiary cannot be the trustee. With an able account, the person can manage his or her own assets. So it's really geared towards somebody having self-determination. We don't do very many of them. Many times it just doesn't fit the situation very well. So we really don't do those very often. Oftentimes we'll be doing the self-settled trust instead. Somebody pointed out that small custodial accounts can go into an able account as opposed to a self-settled trust. Correct. The ones I'm talking about are a little bit larger where you're over the limits. But yes, you can do that instead. I see one about a 401k. This brings up a good point, is that you can name a retirement account, beneficiary of a retirement account into a third-party supplemental benefits trust. But I don't recommend it because retirement accounts are going to have mandatory distributions over a 10-year period of time following the decedent's death. And if there's a mandatory distribution to somebody, it can then interfere with those government benefits. So what I recommend as part of the planning process is if you can kind of move pieces around and there are certain assets going to a disabled child on government benefits, and then there are assets going to a child that may not be on government benefits, it may be a better idea to leave the retirement accounts to the child not on government benefits, and then maybe leave other assets in the trust for the benefit of the child on benefits and equalize the estates, not necessarily 50-50 down the middle per asset, but more into pots of assets if you're going to want to equalize the estate. Like it would be better to leave insurance to a supplemental needs trust and retirement accounts maybe to outside the supplemental needs trust. So those are more details in the fine tuning when it comes to doing the actual estate planning. Okay, so we are now past 8 o'clock, and I know we allotted that. We tried to get to as many questions as we could along the way, but that is the reason that we are happy to facilitate additional questions by Zoom or by email. We will be sending, or Jody will be sending, a follow-up email to everybody that was registered with an invite if anybody would like to have, personal questions or private questions that we can answer that we weren't able to get to today, and discuss situations on a more individual basis. So I appreciate everybody's attention. I always like to see that the participants remain steady for the entire thing. That's always positive feedback. So I appreciate you hanging in there. Like I said at the beginning, this was really just intended to be kind of a sample of things to think about, just different bullet point topics to think about as you evaluate your own situations. This is only the tip of the iceberg. There are so many details with each of these topics that really require further consideration, and we're happy to help you work through those questions if you so desire. So I appreciate everybody's time. Again, thank you to everybody to help put this on. I thank Shawna for missing bath time and bedtime for this, so I appreciate that.
Oh, that's okay.